Federal Railroad Administration Office of Railroad Safety Hazmat Material Compliance Manual, December 2011. Chapter 8, Enforcement Compliance Program Tools. The Office of Railroad Safety continues to increase emphasis on the data-driven safety analysis of the National Inspection Program. National Inspection Plan is one method of improve efficiency of the safety for resources of focusing on the most serious safety concerns. Communication safety data and emphasis of safety result are critical to the success of the FRA Enforcement and Compliance Program. 8.1 Railroad Site Oversight. Railroad System Oversight is one of the FRA processes to achieve the regulatory compliance and encourage railroad labor management participation in developing, measurement, and enhancing the safety fostering environment that improves the safety of railroad operation, focusing on the railroad as systematic safety. The safety issues concerningly addressed by the process include those that may result in the lack of system controls with the manifest across the entire system or the regional local nature. The FRA Railroad System Oversight Manager acts as the FRA safety advocate with the senior level railroad manager, labor organizational liaison, recalibration, labor senior railroad managers are critical tools used to resolve non-regulated safety problems. However, in compliance, established regulation generally will be addressed throughout the FRA's enforcement policy. 8.2 Focus enforcement. The focus enforcement means the FRA's limited enforcement result awards is to address the most serious persistent compliance programs. The FRA inspector should utilize the FRA accident and incident inspection data available agency security site, as well as the data available with the other sources of the PHMSA to gain better insight of the type of the violations actually causing large number of accidents, incidents, or injuries. The information inspector will be equipped with the way of the discretion with the criteria concerning with the inherent seriousness violation, level risk of the proposed, the specific circumstance of the enforcement decision should not be entirely driven by the data inspector directly. Observation experience will also be necessary elements of any of the enforcement discretion activities conducted in this area reported in subpart D, sub source code D, special inspections or investigations. 8.3 Unusual problems and occurrences. Inspector shall notify his or her supervisor of unusual problems, occurrences related to the inspection. Appropriate supervisor shall consult with the Hazardous Materials Safety Division staff. Director, unusual occurrences shall not be documented with the use of email, inspection report, or memorandum. 8.4 Imminent hazard and potential violation. The term imminent hazard means existing condition relating to the hazard material presenting substantial likelihood to death, serious illness, severe personal injury, or substantial endangerment to health, property, environmental may occur before the reasonable foreseeable completion date of a formal proceeding begins, with lessening of the risk of the death and illness and endangerment. 49 U.S. Standard Code 51025. Occasionally, inspector may encounter the situation involving the imminent hazard or possibility some of the one intended to violate the continually violate the hazardous material regulations. In situation where the inspector needs to take appropriate action, promote safety, to be careful to be not outside the scope of his or government duties. The inspector does not believe the imminent hazard related to transportation hazard material exists. The inspector should follow these general principles. 2. Advise the parties of potential imminent hazard, the applicable regulatory requirements, penalty, consequences for the non-compliance. If no one else is advised the emergency response agency imminent hazard of the imminent danger, do so. Do not order or directly parties to take or not take a specific action for the party's action clearly contrary with the hazard material regulation could reasonably result in severe consequences, including death or injury. If the action is to be taken with the gravity of the immediate situation, an inspector should immediately notify his or supervisor of circumstances of the inspection action analysis situation resulting in a decision, as well as the potential consequences if the inspector has not interceded. When the inspector believes an imminent hazard may exist, the inspector shall ensure that the involved parties are be aware of the responsibility of human hazardous material regulation. However, the inspector should not be taken to take charge except to carry out the responsibilities of regulated parties, although to be advised by the individual parties, the applicable regulatory requirements and prohibitions may be very carefully not to order, direct, instruct, mandate, and particular actions be taken, order, directing, instruction, mandating any action being taken beyond the scope of the inspector's authority could result in improper imposition of personal legal liability. Instead of giving orders that directly regulated parties should be advised with the regulations required by the inspector to be advised with the failure to comply with the regulations could result with the imposition of civil penalties, but the pair already applies to the need of additional reason for the complying with the regulation. Inspector certainly explains that the party has been advised with the regulation required, but the party's subsequent violation of the regulations could be considered willful, the subject to possible criminal prosecution. Significant difference between telling someone what the regulations are required to prohibit, and two, the different ordering someone to do something, prohibiting someone from doing something, or letter actions can be resistant legal actions of the individual inspector for the action outside scope of his or her official government duties. The following example to demonstrate the difference: assuming to discover hazardous material on a compliant company ship dock that is not approved or non-conforming package, the shipment does not comply with the regulation and appears for the further transportation. Packaging is likely should advise the company, one, that shipping with the requirement that has material involved, the failure to comply with the regulations could result in substantial civil penalty with the offer of the carrier. 3, if necessary, the company and the individual employees may held personal liable subject to the criminal prosecution if they proceed to willfully violate the regulations. You should not prohibit the company from shipping the materials until they are properly packed and the distinction between advising that ordering is so critically that it should be explicit that they are not ordering prohibition of specific action. In this example, you might say the regulation special Title 40 CFR, the Title 49 CFR requires the hazardous materials shipped with the transported to UN standard packaging, specifically if they are shipped if they're in transportation packaging does meet the requirements to the company, and you other individuals may subject a civil penalty of $50,000 per violation, $100,000 if someone is killed and injured. Also, the carrier is likely to be subject to civil penalties in addition because I have now told you that what regulations require. If I go ahead with the skip these hazardous material in this packaging, you personally and the company may be subject to criminal penalties involving up to 5 years imprisonment and fines of quarters to $500,000. I'm not telling you what to do or ordering you. I'm simply telling you the regulations require you to what do penalties prescribed by the law could be the violation of duty that you understand. Any listener should clearly understand that not ordering anything to be done because of the importance of what you say right down on the statement just after making it. You should attempt to make the statement and further another investigator or law enforcement official, some neutral party, because the witness of the other than affected parties may later prove to be useful. As discussed in Chapter 2 of this manual, the Department of Statutory Authority of Title 49 U.S. Standard Code 5121 was amended by the Hazmat Material Transportation Safety Security Reauthorization Act of 2005, specifically authorization agents and secretary to certain actions to address unsafe condition practices. Defense authority is directly applicable to the situation when the inspector believes the imminent hazard related to the transportation of hazardous material exists. As also noted by the Chapter 2 Hazardous Material Safety Administration published a notice of proposed rulemaking October 2nd, 2008, proposed department-wide procedure for implementing this enhanced authority for the following rule that has not been published and would be allowed in the FRA implementing the enhanced authority. Accordingly, the final regulations are promulgated. The FRA has issued a specific guidance and field enforcement personnel as how to implement such regulations. Inspectors' office of railroad safety enforcement personnel should follow these guidelines discussed above. Alright, 8.5, determining when and what enforcement action is needed. The FRA does not have a formal enforcement action every time the discoverer learns of the deviation of the federal railroad safety laws. The FRA has an enforcement discretion and can choose which violations to pursue pursued based on its resources, which it believes is the best method of promoting the compliance. Inspector regional and headquarters personnel periodically analyze the relevant data and the incidences inspections to determine the pattern of noncompliance, other probable areas, the necessary more stringent broad-based enforcement actions. Conversely, data including indicating the railroad shipper as an overall good of the safety record, particularly regarding the specific regulation in question, might dictate less stringent enforcement measuring such informal warnings. Civil penalty enforcement system, while only one aspect of the FRA safety enforcement scheme is absolutely vital with the FRA safety mission. The FRA decides the enforcement action is called for. The range of the enforcement tools discussed below has the authority to choose the best suited for the circumstances. One of these tools with the emergency order can be used to address an immediate hazard, even though an existing law has been violated. Consisting of the broad enforcement of discretion concerning when and where what enforcement action is necessary, calls for the general guidelines to ensure that the effectiveness, fairness, and acceptability consistent with the exercise that the discretion. The purpose of the guideline is not to dictate absolute identical treatment of the identical situation. That would be an unrealistic idea based on the false assumption that each of the many of the variables going into the enforcement decision could be objectively accurately be quantified. Instead of the purpose of the guidelines controlling necessarily subject elements of the purpose as much as feasible, requiring for the making of the enforcement decision, weighing of the same factors, making the full use of the objective information bearing of those factors, if in which way the appropriate enforcement tools is applied with the response of the discretionary judgments are made, and an acceptable level consistent in similar situations is achieved. 8.6. Factors to consider. Appendix A of the Part 209 explains the FRA exercise enforcement discretion list of the various factors inspectors consider in determining what incidents of regulatory statutory noncompliance merit recommendation of assessment of the civil penalty. Those factors are inherent seriousness of the condition of action, the kind of degree of the potential safety hazard the condition of action poses in light of the immediate factual situation, and actual harm to the person, property, or already caused by the condition or action. The offended person, i.e. the railroad individual general level of the current compliance is revealed by the inspection as a whole. The person recent of the history compliance with the relevant set of the regulations, especially the specific location, division of the railroad involved, whether a remedy other than civil penalty ranging from the warning to an emergency order. This is more appropriate under all the facts. Some other factors immediately circumstances may relevant. The following discussion briefly addresses each of these same factors intended to describe the process that should go into weighing each of the factors. More detailed discussion of each of the factors found with the General Manual, Part 2, Chapter 4. Alright, 861, inherent seriousness of condition of action. Abstract, when the immediate circumstances are not considered, every violation is more or less severe than the others. For example, a hazardous material shipping paper that is incomplete but still contains enough information to enable the material to be identified as less serious than a shipping paper that does not permit such an identification to be made. A good source of relevant information to help determine the inherent seriousness of the condition of the action, national data on accidents, incidents, hazard material releases viewed over the time of the most recent 2 to 3 years. The FRA Safety Database historical incident reports maintained by the Blind Hazard Materials Safety Agency, or FRA Form 5801, provided this type of information. Although these databases provide useful insight, it can be the dangerous violation that use of the hard data determining an inherent seriousness of the condition of the action. Limitations such as data reveal the little or nothing about the violation of the obvious seriousness, and an accurate shipping paper that can interfere with greatly an emergency response. Because inherent seriousness of difficulty applied with the discipline is usually considered to be relatively mannered with each of the discipline. This is the regional headquarters specialist could play a significant role in explaining the relatively severity of the various violations. Especially, the care should be taken to keep the inspectors away from the specific type of violation that are causing the increased portion of the accidents, and so that the inspector can focus on those violations' possible enforcement actions. Relatively non-serious violations not automatically exclude the candidacy for the enforcement only when all the criteria have been considered by it can be made a decision been made. Consideration of the inherent seriousness of violation is a good place to begin, and other factors do not point toward enforcement action. Relatively non-serious violation is a poor candidate for the enforcement action, is likely to produce little or safety benefit in return, but the FRA's resources expended on enforcement. Alright, 862, the kind of the degree of potential safety hazard the condition action posed in light of the immediate factual situation. Well, the first factor focuses on serious part of the circumstance. This factor focuses on all the potential injury, property damage posed by the violation consistent with the actual facts. For example, the hazard material defect failures to secure all openings of the tank car may create more or less a potential hazard depending on the nature of the material, whether a leak actually occurred. Note, however, that an inclusion that little or no actual hazard was caused by a violation does not automatically rule out the need for enforcement action. 863. Any actual harm to the person, property already caused by the condition or action. The ultimate goal of the FRA regulatory enforcement program is to prevent death and injury to the person, to damage property caused by the unsafe behavior. Accordingly, the enforcement action should always be taken where the violation either caused by the contributed to the severity of the harm of the person or property. The violation report itself must explain the causal link between the violation and the harm. The violation need not to be the sole or primary cause. It need not have been caused by at all of it contributed to the severity of the harm. However, it will not suffice simply to say that the violation in some actual harm considered. Shipping paper violation is discovered on a train involved with the actual fatal accident, but the violation played no apparent role in the accident cause or severity. If there's no relationship between the violation and the harm can be shown, the violation may be strong in the candidate for the enforcement, but not based on the consideration of the factor violation report. In such of the cases, must explain the extent of the harm. For the example, rather than simply stating that two persons were injured with the violation, reporting should be discussed with the nature extent of the injuries. Their case with inherent strong candidates for the extraordinary impairment, the rare or should provide information necessarily to support such a claim. In recommendation for extraordinary penalties, the maximum penalty, multiple day penalty, or a total fine of $100,000 more related set of violations must be submitted to the office of the chief of the council for the memo signed by the regional administrator explaining the rationale for the recommendation. 864. The offending person's general level of current compliance is revealed by the inspection as a whole. Most of the FRA inspector's investigation entailing the observation for more than one event with the piece of the equipment that enables the inspector to draw a conclusion about the railroad officer's general level of compliance at the current time. At one end of the spectrum, the factors could lead the inspector to conclude that a violation is merely an aberration, enforcement action not needed to encourage compliance. At the other end of the spectrum, violations may be common for the enforcement to obviously in order. Ordinarily, of course, the facts will somewhere be in between, requiring the inspector to balance the factor against the seriousness of the violation and other factors. On the other hand, the inspector might reveal that multiple violations that, even though not serious in relative terms, indicate a very poor compliance program on the part of the company, and this could lead to the inspector recommendation enforcement action on some of all variation discovered. All right, the person in recent history of the compliance with the relevant set of the regulations, especially with the specific location of the division railroad involved. Historic record of the company owners of the individual compliance with an important factor to be weighed. The important of the area, the office of the railroad safety with the regional specialist. I hope the inspector shifts and the red data with the importance indicated by the inspector of their own possession and their own impression of the companies in the specific location based on an experience, resource limitation, prevent inspectors from getting to all a location that as frequently as would be preferred, but the inspector is equipped with the national regional data on the company may be better to the focus of the inspection more or less inclined to take the enforcement action depending on the broad picture of the compliance. The factors aimed primarily at either spotting patterns in non-compliance that might not be apparent with a single and isolated inspection of the patterns of good compliance that might temper and an inspector reaction to and otherwise unsatisfactory inspection. Although the consideration of these factors should be raised will be based on available data. There's no rigid prescription for which the data include. Generally, the older the information, the less useful it is. Non-compliance 4 years before the inspection is not very meaningful. The more specific information, that more useful it is. Clustering of the violations, particular regulations over time, may indicate that the need to come down hard on any such violation currently discovered, especially in the violations are serious. Focusing the review of the historical data on the particular facility presently involved in making the sense if one of the facility division managers to achieve the very high level of compliance as compared with the rest of the company industrial generally, they argues encouraging such of the efforts of restricting enforcement actions on the most serious matters. Of course, in one facility clearing out of line in terms of the historical current compliance, they argue so that for taking the enforcement action on less of the serious violation in order to increase the deterrent effect of spotting broad trends in the data, particular railroad frequent non-compliance with the hazardous material placement regulations. They may have the systematic cause is the job of the regional headquarters specialists aided with the observation furnished within the field. Together they can devise the enforcement strategy. The recommendation of the office of the chief of the council that an action of the injunction against the civil such violations be undertaken that representative of the pattern of violations that are apparent from the analysis of the overall data. 866 866 whether remedy other than civil penalty is more appropriate under the circumstances. The FRA has more than two options: civil penalties against the company and the warning availability of the effects of non-compliance. Civil penalties against individuals are one option. Emergencies, orders, compliance orders, railworthiness directives, injunctions, other possibilities as criminal prosecution, and it may be the combination of these options. Civil penalties against the company and warnings of a responsible individual would be the best way to ensure the safety and deter non-compliance. All right, 867. Such other factors and immediate circumstances make me relevant. The foregoing list of non in all inclusive but specific situations may involve the specific facts that do not fall under any of those headings but need to be figured in the decision whether to take the enforcement action. Perhaps the most common additional factors is violators' culpability, the relative degree of the blameworthiness, and hazard material causing case. The FRA must show that violative acts were committed knowingly. Hazard material civil penalties caused against individuals. FRA must show that the violation was committed both knowingly and willingly. All right, and then we're going to take a break here.